Welcome to Constitution Guy videos. Today we'll be talking about 3 free speech myths. Malak Afaneh, a student at the University of California, Berkeley Law School, recently attended a dinner party held by Dean Erwin Chemerinsky. She brought a megaphone, which she used to give a speech protesting the treatment of Palestinians in Gaza. She then refused to leave. Ms. Afaneh claimed that she was exercising her free speech rights. Dean Chemerinsky disputes this. Who is right? We should probably split this question into 2 parts. First, was Ms. Afaneh's behavior when she started speaking protected by the First Amendment? Second, was her refusal to leave the party protected by the same amendment? Let's start with the easy one, Ms. Afaneh's refusal to leave the party. There is a common myth that civil disobedience is protected free speech. This is not true. By refusing to leave, Ms. Afaneh was intentionally trespassing on private property. When you break the law to protest government policy, this is not protected by the Constitution. Reverend Martin Luther King, the icon of the civil rights movement, is proof of this distinction. Reverend King engaged in many acts of civil disobedience, such as refusing to leave whites-only lunch counters. He was also imprisoned for these acts many times. But just because his actions were politically motivated, it didn't mean that they were protected by the Constitution. Second, let's talk about Ms. Afaneh's behavior before she was asked to leave. This leads us to myth number 2, that private entities can violate your First Amendment rights. For instance, former President Trump has claimed it was a free speech violation when he was kicked off the social media site Twitter. Harvard University President Claudine Gay testified before Congress that free speech limited her ability to discipline students calling for the genocide of Jews. And the DePaul University Young Americans for Freedom claimed their free speech rights were violated when Ben Shapiro, a conservative provocateur, was not allowed to speak on campus. When will people get this right? Twitter, Harvard, and DePaul universities are all private entities. The text of the First Amendment only applies to Congress and then to the states after the ratification of the 14th Amendment. Private entities have no constitutional obligation to allow for free speech. So how does this apply to the Chemerinsky dinner? It's actually a complicated question whether this law school party should be considered a government event. The University of California, Berkeley is a state-run school, and it turns out the university not only posted the invitation for the event, but it paid for the dinner. So it would take a court to figure out the answer to this fact-specific question. But that wouldn't answer whether Ms. Afaneh's free speech rights were violated. Even if the party was state-sponsored, does that mean that the invited students could behave any way they wanted? This brings us to myth number 3. That as a speaker you can decide the time, place, and manner of your own speech. In constitutional parlance, the party would be considered a limited public forum. Because of this, the hosts were allowed to set the rules of behavior, which obviously did not include using a megaphone to give speeches. Bottom line, the host did not violate the protesters' free speech rights. So what is the lesson to be learned here? Well, if you want to engage in civil disobedience, go for it. Just don't expect the First Amendment to come to your rescue.